Hi, this is Cora Stack here, Dr. Stack. I want to just address something to do with a case that I have seen reported in the newspapers regarding whistleblowing and the WRC, the Workplace Relations Commission, which is an adjudication authority, but it doesn't have the same. It doesn't seem to have the same separation of powers or laws that a court has. So it's a quasi legal institution. So I assume that all of the adjudicators are quasi legal. They're not judges in the sense of being in the courts, and that there isn't there isn't a kind of separation of powers there that there would be in the courts, as I understand it. So I'm always open to corrections. So the title of this video is Closed Doors, Transparency and Human Rights at the WRC. So as I understand the case, in February 2026, the state successfully applied for a hearing before the Workplace Relations Commission, the WRC, to be held in private. The case concerns a senior Garda officer who has brought a whistleblowing claim. Its penalisation is all that I understand. That's the only thing that it does, is the penalisation aspect of the act, as I understand it. The media and members of the public were directed to leave the hearing room. The adjudication officer granted the application for a closed hearing. These are the facts, as I understand it, as reported. Context: the Workplace Relations Commission is a statutory body established under the Workplace Relations Act 2015. Following the Supreme Court decision in Zelensky, this was a very important move by this particular person, Zelensky versus the WRC in 2021. WRC hearings are recognised as exercising a very important issue, an administration of justice function. Like judges, administrative justice, was that 35 or 34? Maybe somebody remind me of the article. I'm forgetting it already. WRC hearings are generally public by default. However, the law allows the press and public to be excluded in certain circumstances. Under Article 6 of the European Convention on Human Rights, everyone is entitled to a fair and public hearing. The same article permits exclusion of the press and the public in specific situations, including national security, protection, private life, or where strictly necessary in the interest of justice. Let's look at the situation in this case. The claimant is a senior Garda whistleblower, as I understand it. The respondent is the state, as I understand it. The hearing is taking place in private. The media and others have been excluded. No public hearing of the evidence is occurring. The substance of the proceedings cannot be reported. Questions about transparency. Public hearings serve several purposes. They promote transparency. They protect against secret justice. They maintain public confidence in legal institutions. So this raises the questions: what specific legal grounds justified closing this hearing? Were those grounds fully explained on the record? Were less restrictive measures considered? Could parts of the hearing have remained public? Questions about proportionality. Under human rights law, restrictions must be proportionate. This means they must be strictly necessary. So we might ask, what harm would have arisen from a public hearing in this case? Was the exclusion limited in scope, or was it total? Will a detailed written decision be published afterwards? Will the reasoning for closing the hearing be made public? Questions about whistleblower protection. Whistleblower cases can involve sensitive disclosures. They may involve personal safety, operational security, or reputational concerns. So questions arise: did the whistleblower respect privacy? Was privacy necessary to protect sensitive operational information? Does closing the hearing protect the whistleblower or reduce public scrutiny? Question about equality of arms. The state is a repeat institutional litigant. It has access to huge public legal resources. So another set of questions emerges. Does a private hearing enhance or reduce accountability? How does confidentiality affect perceived fairness? Does the public have a legitimate interest when allegations concern state conduct? And my answer to that will be yes, they do, in my opinion. but I'm just asking the questions. Democratic considerations. This is very important. When the state is party to proceedings, transparency can take on additional importance, particularly given the power asymmetry, the power imbalance, you have between, the state having all access to the best and the biggest set of legal, armies in the country, compared to a litigant, that might not have the resources to, well, they wouldn't even have access to that level of representation, inverted commas. Public institutions derive authority from public trust. So we might ask, how does secrecy affect public confidence? Should allegations of penalisation by a state body be heard publicly unless exceptional circumstances apply? Where is the balance between confidentiality and democratic oversight? This is, I think, very important. Closing. The law permits closed hearings. The law also protects the right to a public hearing. The case sits at the intersection of these two principles. The key questions are not whether closure is ever lawful. The key questions are, was this necessary? Was this proportionate? And does it maintain confidence in the administration of justice?